Bonjour tout le monde. Hello everyone. Je suis extrêmement heureux de vous accueillir aujourd'hui pour une nouvelle conférence virtuelle de l'initiative IA et Société. I am delighted to welcome you today for a new AI and Society virtual talk. For those who don't know me, my name is Florian Martin Barreto. I am an associate professor of law and the University Research Chair in Technology and Society, and the director of the Center for Law, Technology and Society at the University of Ottawa. I'm also the director of the AI and Society initiative that is co-presenting this event. For today's virtual event, presented in partnership with the Shirley Greenberg Chair for Women and the Legal Profession at the University of Ottawa Faculty of Law, we are hosting a conversation with Dr. Bita Amani from Queen's on the need to rethink the regulation of algorithms with equality by design principles. For those who don't know, Dr. Bita Amani is an associate professor at the Faculty of Law at Queen's University in Kingston and the co-director of the Feminist Legal Studies Queen's. She's also an adjunct professor of law at Osgoode Hall and a lawyer with Spark LLP. Today, Dr. Amani will present a recent work that she published as part of Artificial Intelligence and the Law in Canada, a recent edited collection that I actually led with Dr. Tirza Scassa, and that was published a few months ago by LexisNexis Canada. You're free to obviously buy the book. That is an amazing collection. But as I would like to note that the book will be made available in open access in a few months, early 2022. So after the talk, Dr. Amani will be joined by Ewan Stevens, who will facilitate the Q&A session. Ewan is a research fellow with the University of Ottawa Research Chair in Technology and Society and an articling candidate for the Law Society of Ontario at the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic, CIPIC. So without further ado, I will give the floor to Dr. Bita Amani. And as a reminder, I will invite you to ask your questions in the chat. And Ewan Stevens will read the question and feed the conversation from what you will have commented in the chat. Thank you so much. Bita, the floor is yours. And your slide should appear in a few seconds.
Great. Thank you so much, Florian. Good day to everyone, wherever you are, and thank you for joining in this session. I appreciate your time and generosity in sharing it with me today as we look to have some advancement in the discussions regarding AI and equality by design. I'd like to begin by thanking the AI and Society Initiative and the Scotiabank Fund supporting the initiative, and the Shirley E. Greenberg Chair for Women in the Legal Profession for hosting my talk, with special thanks to Dr. Florian Martin Berthaud and Justine Dazé for facilitating, and Ewan Stevens for kindly agreeing to moderate. I join you today from what is known as Toronto, the Dish with One Spoon territory. It is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and now home to many diverse First Nations, Inuit, and Métis peoples. The city is covered by Treaty 13, signed with the Mississauga of the Credit, and the Williams treaties signed with multiple Mississauga and Chippewa bands. I thank the land, the ancestral holders and stewards of the land, and all of its inhabitants for sharing the space with me where I get to live, work, and play as an immigrant settler who has the privilege to call this land home. In my brief time with you today, I'll be drawing key discussion points arising from my recently published chapter, as Florian mentioned, in the Martin Berthaud Scassa book. And so this talk has gained a bit of traction, so it's been on tour for the last little while. And so my apologies for any repetition for those who may have heard it in other fora. So I will begin by looking at a number of, so in terms of the roadmap here, I will begin by just looking at or raising for consideration some of the provisions for protecting equality in instruments governing human relations. So these are international human rights instruments, such as the International Covenant for Economic, Social, and Cultural Rights, the International Covenant for Civil and Political Rights, the UN Declaration of Human Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, as well as with some consideration to national implementation of equality rights in the Canada Human Rights Act and in provincial law such as the Ontario Human Rights Code, as well as a contemplation of equality as a formal constitutional right within Section 15 of the Charter as well. We'll take a look at some examples of discrimination and inequality and land, hopefully, in a discussion that moves us from equity to equality, moving beyond fairness as ethics and the ethical discussions or the discussions of ethical AI to the discussions of what is required legally as a right, and within that right, the concept of substantive equality for ensuring equality is preserved in a meaningful way in a manner that maintains the dignity of all individuals of the human family. In that context, I'll be discussing with you my proposal in the chapter for equality by design, and we'll end with some concluding thoughts regarding law and legal practice. Okay, so just to then start off then here, then we see that there are a number of instruments in which equality is protected as a human right. So these are international instruments that obligate states, including Canada, to recognize the equality of all members of the human family with the recognition of the human right to equality, to be free from discrimination, as well as other rights such as the right to privacy, and there's provision made in some of these instruments for the progressive realization of some rights towards their full recognition by all appropriate means, including adoption of legislative measures, while also by the same provision allowing parties to undertake and requiring parties to undertake to guarantee that the rights enunciated in the covenants will be exercised without discrimination of any kind as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. So we can ask, how meaningful would human rights be without equality to ensure the distributional equality in rights recognitions? And so the human rights framework is key and has gained a lot of traction in the emerging literature as an appropriate framework for ethical AI, responsible AI, trustworthy AI, and so forth. We see, for example, in Article 3 of the International Covenant for Economic, Social, Cultural rights that beyond non-discrimination, some rights equality needs to be recognized for men and women on equal footing with equal opportunity, and that the parties take to ensure equal rights of men and women to the enjoyment of all economic, social, and cultural rights set out in the covenant. There's a right to work, the right to enjoyment of just and favorable conditions of work, fair wages, and equal remuneration for work of equal value without distinction of any kind, with equal pay for equal work, so Article 6, Article 7, and so forth. And so these are requirements that entrench equality as a right that are really not meant to be subject to considerations other than there's some allowance for seniority and competence, but as I will suggest to you later in this conversation, the concept of merit itself is an elusive and illusory, perhaps, concept that needs to always be assessed and brought in the context of its broader social dynamics for assessment, as well as the metrics for assessment. So a human rights approach preserves the human dignity of each individual while also recognizing the broader community to which the individual belongs, and allows us to proceed from there. The International Covenant for Cultural, Civil, and Political Rights similarly also recognizes that all persons are equal before the law and are entitled without discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination, again, on any of the prohibited grounds identified. Yet, international human rights law has generated considerable challenges to their justiciability for the individual internationally, and of course, within domestic law as well, given that they require domestic implementation, although they have been used to inform the illegal interpretation of laws otherwise as well. So there is this justiciability problem of what are otherwise universal human rights. Fortunately, of course, we have constitutional protections for equality as a foundational right, and Section 15.1 of the Charter provides that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Privacy is an international human right that is not explicitly recognized as a charter right, but has been recognized by the courts as a quasi-constitutional right that receives protection through Section 8, the right to be free from unreasonable search and seizure, as well as through Section 7, the right to life, liberty, and security of the person, and as a charter value that informs a Section 1 analysis on whether a restriction of a charter right is demonstrably justified as a reasonable limit in a free and democratic society. So there are 3 points, though, as a takeaway then here. One, that the Charter guarantees equality as a constitutional right and the equal treatment of individuals and to be free from discrimination on any of the prohibited grounds. And 2, that subsection 2 provides that Section 1 provision does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those who are disadvantaged because of race, national, or ethnic origin, and so forth. And so the component here that is key then is that special provision is made for discrimination to occur where it is designed to advance substantive equality. So special affirmative programs are permissible because they're meant to address and remediate existing structural inequalities and systemic harms. And such provisions also have their counterparts in international instruments, including, again, the Convention on the Elimination of Discrimination, all forms of discrimination against women, which also allows for special affirmative programs under the Human Rights Code as well. And so we see, while the Charter right is in part remedial, and you can in fact seek charter damages as well, it does not impose a positive obligation per se to eradicating inequality in the same way that, for example, the Convention on the Elimination of All Forms of Discrimination against Women does, to respect, protect, and fulfill, and to eliminate all forms of discrimination. So within the domestic context, we also see the Human Rights Code. So Ontario Human Rights Code, by example, in the preamble recognizes the inherent dignity and the equal and inalienable rights of all members of the human family as foundational to freedom, justice, and peace in the world. We see the Canada Human Rights Act also focus on the purpose of the act being equal opportunity without being hindered in or prevented from doing so by discriminatory practices based on, and then there are a number of provisions in both of these instruments, including the right to be free from discrimination on prohibited grounds in various areas of application, including employment, as we see here with Section 5 under the Human Rights Code, and under the Canada Human Rights Act, we see, for example, with Section 7 and 8, that it's discriminatory practice to directly or indirectly refuse to employ or an individual or, in the course of employment, differentiate adversely in relation to an employee on a prohibited ground of discrimination. It's a discriminatory practice to use or circulate any form of application for employment or in connection with employment or prospective employment to publish any advertisement or to make any written or oral inquiry that expresses or implies any limitation, specification, and so forth on prohibited grounds of discrimination. And again, we might think about the application of such a provision for targeted ads and recruitment and hiring and so forth. So there are a number of risks then, and that AI raises, as well as opportunities in terms of running afoul of existing law and equality protecting provisions, both domestically and in international law. As I noted in the chapter, artificial intelligence is increasingly offered as a way of overcoming human biases. That is, we have these provisions because unconscious bias, human biases are rampant and they need protecting against. So AI is increasingly offered as a way of overcoming these biases, overcoming errors in judgment, irregularities in decision-making, and promising to provide a greater measure of predictability, consistency in decisions, and therefore the rule of law. And yet, for others, generating consistency in decision-making is a means for entrenching and amplifying discriminatory practices in a way that reproduces privilege and inequality in human relations through the use of pattern discrimination and predictive analytics, while simultaneously rendering them less transparent, explainable, and contestable. In both cases, technology is catapulted to the forefront of law as constitutive of the lived realities and the governance of human relations. And that occurs whether it's in the private or public sphere. And then we have to question whether law itself will too soon become a technology that will be obsolete. Algorithms feed neural networks with neoliberalism's relations of power and inequality, and so they have the capacity to bake in inequality, to reproduce bias, and effectively pass off the descriptive output of code as law, and law as the normative aspirations of justice. And so I argue in this chapter that more than ex post remedial mechanisms in law are needed to address such harms if the rule of law is to retain its comparative advantage. And so it will require, I submit, equality by design, enforceable default value for computer programming that's consistent with the aim of a human rights, human-centered approach to AI governance. And so in that context, then the human rights impact of new tools and applications really becomes key, and as does the methodologies and metrics for assessing the human rights impact of new tools and assessment formats. And we see that in regular hiring and recruitment, there's a lot of literature that already shows preferences, that a lot of employers still make choices regarding hires based on gut instincts and so forth. So, and we can appreciate that when we look at the demographics of individuals, for example, in CRC positions, in top-level positions in the academy, as full professors and C-suite, across the board, that there is a continued rampant inequality for those with intersectional identities, that is, identities at the intersections of various forms of discrimination, so Black women, Indigenous women, and so forth. And that merit itself may be a bit of an illusory concept. So, for example, in April of 2021, Nathan Greenfield reported in an article that the Canadian Human Rights Commission ruled that universities will lose their Canada research chairs if appointments to these positions do not reflect the proportion of women, disabled, Indigenous, and visible minorities in the Canadian population. And this followed on the heels of a complaint filed by a University of Ottawa faculty of law professor in 2016, which in turn had followed on earlier complaints and a settlement that was achieved a few decades ago by 8 female professors who filed a complaint alleging that the federally funded program discriminated against women and the 3 other groups identified by the Canadian Employment Equity Act. And according to Professor Adoran from Ottawa U, the issue is whether the federal government is subsidizing discrimination or subsidizing equity, as quoted in this article. The CRC program disperses $395 million a year to fund 2,285 chairs in 76 universities, the article reports. So we see then at the level of knowledge creation and production, there is inequality, and I will carry you through in this discussion through the sort of the life cycle of that in terms of its implications, but certainly that's part of the issue to be addressed. On that basis, then, we could see why using AI tools in hiring and employment decisions and so forth may at first blush seem attractive. And yet, for example, as with this study, we see that the assessment of the tools for AI and human resources and recruitment and hiring fared far worse in terms of its human rights impact than, for example, by comparison, the use of tools to access financial systems and reflect on credit scores. So they looked at, I think, 6 different areas. I have 2 represented here. The yellow shows indeterminate consequences, the red shows negative anticipated consequences for human rights, and the blue shows potential positive gains. So, for example, you see with the financial systems credit scores assessment that benefits were to be realized in terms of human rights implications for the right to equality with the use of AI tools, as well as with access to accessible standards of living with the tools in this regard. So part of the then when we look at the data then is to assess the benefits of and also the risks of the human rights risks of various tools in different contexts, and to consider these in light of obligations to advance and promote equality. So data analytics may actually help us assess areas where inequality exists. So going back to, for example, whether it's in organizations and the demographics of the employees at certain levels or in other institutional contexts, as Iris Bonet has demonstrated in her book, What Works? Gender Equality by Design. She talks about how unconscious bias is everywhere, how de-biasing the mind is hard to do, doing it yourself is risky, and getting help only takes you so far. She's dedicated chapters to each of these topics and talks about how simple design changes have been shown to have significant results. So, for example, in overcoming gender disparities in professional musical orchestras and behind curtain auditions. And so applying data analytics to people decisions may help identify the need for smarter evaluation procedures and so forth. But the potential uses, as we see, grow increasingly problematic beyond the last slide that I showed you with respect to recruitment and hiring and financial systems and scores, but also to the use of emotion affect recognition and the increasing use of emotion affect recognition as part of the tools, and they occur also within the employment context, of course, insofar as using face and voice analysis may inform various competencies and characteristics or suitability for employment and so forth. So emotion affect use is, again, yet another area that, as with all these areas, we need to ask, what is the impetus of using such a tool? Who benefits? Who is harmed? If AI tools are to be deployed, they need to comply with the law and ought to conform to value-based equality by design, consistent with a human-centric approach to regulating AI. And so some tools, such as this, some argue should be banned altogether. With the context of such tools, we see the critique being raised from the perspective that the actual original classification and the taxonomies associated with facial recognition are flawed. They have cultural assumptions that are advanced and perpetuated with those labeling mechanisms that result in disparate impacts and discriminatory harms. And so, for example, Kate Crawford in her 2021 book, Atlas of AI, has a section on emotion profits, When Feelings Pay, in which she discusses the work of Paul Ekman, an American psychologist who arrived to study a remote indigenous community, the Four People of Okapa of Papua New Guinea, as so-called ideal subjects given their social isolation. And he was looking to test his emerging theory on universal emotions and affect that all humans display as natural, innate, and cross-cultural, and proceeded then to label emotions by proxies that he ascribed to them, and weighted in without any training in for history, language, culture, or politics, Crawford notes, which in turn, of course, raises concerns regarding ethics and scientific doubts regarding the veracity of such labels to reflect emotions. Increasingly, affect recognition is built into facial recognition, speech and voice recognition, and various machine learning platforms, and is a multi-billion-dollar industry expected to grow exponentially in the next 5 years from current projections, from current amounts around 19.5 billion in 2020 to approximately 37.1 billion by 2026, according to some reports. So this is an area that's clearly contested, especially for its potential discriminatory impacts. Given the original theory on which such tools are based and facial recognition expressions are classified is found to be increasingly culturally nuanced, with meanings and classifications that are situated and socially constructed. So we will have to also consider the training data and what regard is given within this data to broader considerations such as disability and whether facial expression or capacity to infer affect or any personality traits from facial expression can be adequately reflected in given the training data that is used for informing such analyses. If such tools are true, and such applications can show a person to be angry or sad, then where would this leave those with depression and mental health disabilities that might be captured by the human rights protections and equality protections? Might we also expect potential intrusion on seclusion claims and or claims regarding public disclosure of private facts? We might ask whether consenting to a hiring process is in fact consenting to non-voluntary extraction of such data. If such tools are false in terms of the results, then we should be addressing these in terms of false and misleading advertising in relation to the products. And we can ask whether they actually do have the capacity to deliver on what they promise and pursue those considerations from other ways as well, such as false light claims or, again, intrusion on seclusion privacy claims may be coupled with Sale of Goods Act potential considerations regarding fit for use and purpose. It may also be time to revisit the tort of discrimination, which failed in the Beduria case to be recognized by the Supreme Court of Canada, and yet times have considerably changed since then, which may require us to revisit such considerations. Other examples in the law that are replete include, for example, natural language processing used in screening resumes. That's also proven to be very fraught. So Amazon's tool was scrapped due to discrimination against women and penalizing and deprioritizing resumes that had women's, as in women's college or women's chess club, reflected in the language. And again, we might consider additional impacts such as chilling effects and freedom of association implications, but I'll just put that to the side for now. In this case, the company was building a computer program to review job applicants' resumes, and the idea here was, again, to facilitate and automate the recruitment process for top talent using software. The tool was ultimately scrapped at the test stage. So the problem really, though, came about because the models were trained on resumes that were submitted to the company over a 10-year period. And the data, therefore, in terms of these resumes, mostly came from men. So it is also in part a reflection of male dominance across the tech industry, as well as preferences that may find themselves encoded in that context. Another report identifies one resume screening tool as identifying being named Jared and having played lacrosse in high school as the best predictors of job performance, according to a report by Quartz. There's also gender bias in language use with preferences for words that may be more common to, for example, male use. So engineer CVs that have the word executed, for example. So such preferences occur, of course, then with human recruiters as well, but they are repeated algorithmically. Human recruiters have their own unconscious bias and preferences based on homophily and similarities and likeness. So we see then at the same time of recognizing all these problems that are covered in the media, we see automatic gender recognition systems are being increasingly deployed in a number of different areas, including targeted advertising, whether it's targeting women with specific artifacts that are considered to be for women, and often these carry differential costs because oftentimes some products cost more for women than they do for men, as with razor blades, for example, or whether it's targeting jobs to women, which may have differential pay than jobs, or be at different not only salary scales but also at different levels of employment than employment opportunities targeted to men. Again, automatic gender recognition advances both stereotypes and inequalities. So there may be assumptions and reinforcement of gender identities as static and binary and fixed in their representation, but also considerations regarding how those identities inform merit and capacity. Timnit Gebru, in her chapter on race and gender in the Oxford Handbook of AI Ethics, notes the devastating effects of automatic gender recognition for transgender and non-binary individuals, and these include from misgendering individuals to outing them in public or to their employers. She references a national transgender discrimination survey from 2014 in the US that notes that 56% of respondents surveyed who were regularly misgendered in the workplace had attempted suicide. And of course, then the stats regarding suicide's correlation with transgender identities and so forth may be used for further harm. So we might imagine higher life insurance premiums, for example, that might follow from that. That would be discriminatory and illegal. So part of the problem then is also tied, as some of these accounts note, and you see that in the slide, is the lack of actual diversity in terms of race, gender, and intersectional identities. What Kimberly Crenshaw, critical race theorist, notably references intersectionality in accounting for individual differential experiences and their intersections in terms of particular disparate harms at the intersections of different identities. So referencing in the context that she wrote to a 1976 lawsuit in the US in which a Black woman brought legal proceedings against General Motors for discrimination and lost on the false assumption that there can't be discrimination when an employer is hiring both Black people and women. So disaggregated data and data analytics can actually help to identify areas of prevalent discrimination for remediation with special programs when we adopt intersectional lenses and approach these things from a position of how, again, I'll reference here Peggy McIntosh's work on white privilege, how white privilege may be informing the analysis and functioning of such tools, and what is given effect, the selection of proxies, the weighting of proxies, and so forth in technological pattern discrimination. Human biases have apparently carried over to robot judges in beauty contests with race as a proxy for beauty. So Ruha Benjamin, in her book, Race After Technology, abolitionist tools for the new Jim Crow, notes that in a beauty contest that was adjudicated by robotic decision makers, robotic judges, all 44 winners across the various age groups except 6 were white, and only 1 finalist had visibly dark skin. So in addition to white privilege, we see androcism is similarly entrenched and amplified as the normative basis for assessment by algorithms. And again, Kate Crawford's work calls artificial intelligence as white guy problem, calls out artificial intelligence as white guy problem, and notes that this is compounded then by existing poor relative demographics in existing academic institutions, and as I've already mentioned with CRC chairs as well, where knowledge is made and produced. We see that in STEMs, and that's of course compounded by discrimination in hiring, promotion, retention of women and people with intersectional marginalized identities. So in a 2019 report, by West, Whitaker, and Crawford, Discriminating Systems, Gender, Race, and Power in AI from the AI Now Institute, the report highlights that while gradually narrowing the lack of diverse representation in major tech companies, that there is considerable still inequality in terms of representation at these companies. And we see that across the board. We also see it in citation practices and academia and so forth. So these problems are, again, they are rampant, but they also generate costs and premiums. So race and gender premiums have been found to result with marginalized individuals not only taxed with EDI, education, equity, diversity, inclusiveness, education, and advocacy, but also with paying higher amounts, as exemplified in this slide, in relation to finance and lending. So in the image on the left from the Business Insider reports, there's reference to a Northwestern University study that found that racial disparities in the mortgage markets have declined haven't declined much in the last 4 decades when it comes to discrimination in loan denial and interest rates, and that Black and Latino mortgage applicants are more likely to be declined than white applicants and more likely to be offered high-cost loans if they're approved, which is referenced as the reverse redlining problem, where individuals may qualify but are penalized with higher interest rates. Another report reflects on the gap, this report from the Urban Institute, on the gap of home ownership rates as of 2017 between whites and Blacks. 72% of white Americans owned homes compared to 42% of Black Americans. And we see that also with respect to gender, right? So we see in terms of reports on gender that there is also a gender premium. So in a 2016 Urban Institute research report, the authors of the report found in studying loan performance for the first time by gender that these weaker credit profiles do not translate neatly into weaker performance. In fact, when credit characteristics are held constant, women actually perform better than men. Nonetheless, since pricing is tied to credit characteristics and not performance, as in performance and repayment, women actually pay more relative to their actual risk than do men. And that's ironic, they note in this report, given that given their better performance, that they're actually being denied mortgages more often than men. And so we see these complications again across the board and in need of remediation and remedial treatment, but often the remedial treatment is too late. That is, the harms have occurred, they've occurred on an individual level, they've occurred on a systemic structural level, and here we might note the limitations of human rights insofar as the need for complaints to be made individually. They effectively shift the burden of equality by automating inequality and add costs and implications, both in terms of evidencing implications, but also the cost of pursuing equality claims, really taxing the individuals for everyday harms that have become ubiquitous with the adoption of technology if the technology is not held to account in terms of its compliance with legal standards. And so this really highlights the difficulty in terms of when code becomes a de facto regulator, right? Automated decisions may, in certain contexts, then manifest in other contexts as ubiquitous law enforcement. We've seen that, for example, with copyright notices and takedowns, for example, without account for other rights such as fair use. And so code, with Lawrence Lessig's formative work of Code as Law, is a regulator that lacks constitutional legitimacy and yet has come to dominate the legal and administration of justice, even as law and information technology reciprocally reconstitute each other. So Lessig contends that a constitutional inquiry of cyberspace requires us to ask what values should be protected there, what values should be built into the space to encourage what forms of life. And these are important considerations for value-sensitive design. Significantly, they are necessary as the machinations of the algorithmic machinery of governance flip the defaults in legal burdens and raise the cost of accessing justice on the most vulnerable within society. So the key challenges in this area then is really to ensure that technological pattern discrimination does not automate and amplify discriminatory applications, to safeguard against automating inequality and injustice with regulatory standards, to adopt laws and policies to ensure fairness, accountability, and transparency in data processing. And I would suggest to embed equality by design and AI regulation to ensure accountability for advancing and enforcing substantive equality ex ante, and then therefore putting the burden on industry and the developers of such tools to ensure compliance. We should also revisit the scope and application of trade secrets protection and other intellectual property rights, which I'll be happy to comment on if asked in the question period. The problem, of course, is that such tools are not limited in terms of their individualized implication. And here, then, we see the challenges of the normative conceptions of, for example, privacy or any rights, therefore, as sort of individualized atomistic rights as opposed to necessarily relational rights and also community rights and so forth. But these harms are experienced in the aggregate by various communities more so than others. So AI tools are designed to discriminate. They identify patterns and engage in social sorting. And predictive analytics relies on data mining and data analysis to locate statistical relationships in data. And these can have a totally devastating effect, as to quote from Hito Sayarel, totality based on probability management probability enters truth production on an extensive scale. Of course, then this requires us to go back and consider the legal implications, and I invite you to have a look at various instruments and the idea of constructive discrimination under those instruments, such as under the Human Rights Code with Section 11. A right of a person under Part 1 is infringed where a requirement, qualification, or factor exists that is not discrimination on prohibited ground, but that results in the exclusion, restriction, or preference of a group of persons who are identified by a prohibited ground of discrimination. So this is an added area of consideration in tandem with some of the other areas I've discussed. So the code protects against direct, indirect, intentional, unintentional discrimination, and discriminatory agency is a discreditable fact that cannot or should not be outsourced to AI. So here I'm referencing Richard Posner's work on the right to privacy, saying privacy protections for individuals should be more limited than, for example, trade secret protection, because privacy is a way of concealing discreditable information that is important for people's relationships in transacting. And I would put to you here that the discriminatory agency is a discreditable fact that cannot and should not be outsourced to AI or protected by trade secrets as well. Human rights decisions teach us something, and we rely on feedback loops for such accountability, but the implication of legal feedback loops are difficult to implement within accountability mechanisms for the machine. Human rights claims require evidence, and that's a problem that's also confounded by end-user license agreements and trade secret assertions. So in this context, then we see the really critical role of and importance of value-based design. We see that value-based design is a way, and has been implemented in other ways with respect to, for example, privacy by design, but it is a measure of helping to ensure the appropriate compliance with existing legal criteria, even as new criteria develops. Designs can generate mismatch with over and under inclusivity. So we see that with North Point Compass software and Amazon's face recognition software. There are very public errors that are drawn. There may be errors that algorithms are making that are not readily picked up. There's lots of literature regarding the implications of this in various other areas. And ways of addressing some of the assessments with respect to the harms that may exist. So, for example, I will just point out there was a report. The need for critical and nuanced metrics for assessing the tools is important. So there's the AI and Bias Policy Lab in March of this year published The Elephant in AI, a toolbox for those in the AI ecosystem to mitigate bias in recruiting and hiring platforms. And Dr. Manish Raghavan in the report discusses the idea of differential validity, the question of how good is a tool at correctly identifying a high versus low performing candidate. How does validity relate to bias? And she notes a key way that such tools can discriminate is with differential validity. That is, if a tool is better at evaluating members of one group than another, such as top performing white candidates over top performing candidates from African American or marginalized community, then this is the idea of differential validity considerations. We might also consider this in terms of predictive parity. So the Compass tool was criticized insofar as while it was able to predict recidivism equally well in Black and white populations, it failed to account for equalized odds, that is, the inequality perpetuated by false positives, that is, that Black defendants not likely to recidivate were 2 times as likely to be misclassified as their white counterparts when assessed on ProPublica's concept of fairness in scrutinizing North Point's Compass program, and also addressing the base rates for recidivism, underlaying the critique of the algorithm as racially biased in the inequality of false positives. So even the carceral knowledge that is drawn from the selective policing and so forth adds challenges of inequality that are compounded and entrenched in these contexts. So there are gaps in the law, and I'm running out of time, so I'm just really going to quickly go through. So there are various instruments and requirements in international law, including the International Covenant on the Rights of Persons with Disability, and including, for example, also the rights to eliminate all forms of discrimination, racial discrimination, in tandem with the CETA obligations that I mentioned that may be effectively implemented through EBD principle that would be entrenched as a legal criteria, a legal standard to be adopted. So we can take some lessons then from the GDPR. Privacy by design is a legal requirement under the European Union's new General Data Protection Regulation, with which all data controllers must comply. The GDPR provides that, subject to some exceptions, including explicit consent, the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significant effects on him or her. And provides obligations to this end. The data controller shall implement suitable measures to safeguard the data subject's rights and freedoms and legitimate interests, at least the right to obtain human intervention on the part of the controller, to express his or her point of view, and to contest the decision. The problem is it's limited to decisions that are made solely through automation, but it does provide a right of explanation with respect to algorithmic decisions. And there are some due process-like rights to human interventions to express an opinion and to contest the algorithmic decision. Trade secret exceptions continue to apply to the right to an explanation and to the related notification and access rights. In the US, we see anti-discrimination audit testing to ensure compliance with civil rights has been upheld in a federal court ruling that held research testing of proprietary algorithms via the use of fake profiles and job postings used on employment websites for race and gender discrimination was not a criminal breach of the Computer Fraud and Abuse Act for exceeding authorized use and violating a web's terms of service. Such decisions are to be applauded, I suggest, for paving the way to scrutinize algorithms by denying criminal prosecution until law reforms arrive. We actually need to go further and mandate such testing with EBD rather than merely provide criminal immunity. So EBD is a legal standard with attendant remedies for non-compliance, as there is with PBD, privacy by design, for example. It would make EBD the default and give it teeth. It may be tied to forms of equality impact assessments, equality audits. We can look at the literature and constantly improve how we may achieve EBD. There may be data statements that might be required for disclosure. So this is standardized information about a population studied, the characterization of the data set, the limits, the potential for bias and discrimination, and so forth. And then just wrapping up here, some concluding thoughts as we move sort of ahead into this new world. We have to consider how law operates as well as legal practice. So there are increasingly new legal tools and these tools include not only automation of tasks, but also outsourcing research and for example, with legal memos on demands. That's not a proxy, of course, for legal opinion. There may be predictions and classifications that result, and yet we do have to make sure that the gains here in terms of cost effectiveness for the client and time effectiveness for the lawyer that allow a lawyer to focus on higher level processing and skill sets of lawyering are not offset by the risks with over-reliance on such tools or the risk of the descriptive outputs of law replacing the normative aspirations of justice, path dependency, entrenchment of disparate discriminatory impacts of the law, commitment to rule orthodoxy versus laws governing social relations, and so forth. So these are simply tools. We should also learn how to advise clients who may be getting direct-to-consumer advising and predictions occurring. So the key challenges then will be, as lawyers and people in the legal profession, to know when to take issue, to ensure technological pattern discrimination does not automate and amplify discriminatory applications, to be able to give legal opinions on risk and exposures of liability. There will be tasks for everyone to get involved in terms of law reform and the safeguarding against automation of inequality and injustice with regulatory standards, and to ensure that laws and policies reflect a just and fair and equal society. I suggest that the way to get there, is to adopt the EBD and to champion equality everywhere, and to correct for and move against inequality wherever it exists. Thank you very much.
Hello, and thank you for that talk, Bita. For those who don't know me, my name is Yuan. I'm just hopping on late due to a scheduling conflict, and I'd just like to invite us all to give a virtual round of applause to Bita for such an amazing talk. I will also be clapping. The little applause will last a few seconds. But yes, thank you, Bita, for such a fantastic talk. And I've read your chapter in the book on AI and law by Professor Martin Barreto and by Professor Teresa Scassa. And I'm going to take us into a time of Q&A. And I do have questions. I'm happy to fill in the gaps. I invite anyone here to type in your questions if you have any. I can already see some coming in. What I'll do is maybe just kick off with one of my own questions, and I'll begin taking questions after that. So I'm just going to take a look at my notes here. So Bita, I know in your talk you mentioned and hinted at this idea that intellectual property law has a role to play in the regulation of AI and inequality topics as well. And I know you have significant expertise in this area of law. So you've worked on issues of trade secrets, patent law, text and data mining as it relates to AI. Can you tell us more about the role of intellectual property rights in achieving quality by design?
Thanks so much for that. Yeah, absolutely. And I appreciate the question because it's work I'm currently undertaking as well as an expansion of this paper as well. So trade secrets and the assertion of trade secret protection over algorithms is a key area that's been commented on by a number of different people in the literature. And it really is a challenge in terms of even in the report that had the two so this is the Artificial Intelligence and Human Rights Opportunities and Risk report from the Berkman Klein Center that had the two graphics up front regarding AI tools and recruitment and in financing. We see them note the limitations of their methodology in doing the human rights assessments based on the fact that a lot of the information is proprietary. So the proprietary aspects may be in relation to the algorithm, but also with respect to the data sets, which may be considered confidential or proprietary. And we see that, for example, in the health context with clinical data and so forth in that regard. We should start with what critical race IP scholars have been doing in the last few years really significantly, which is by looking at the disparate ownership of IP to begin with. Right. So who owns IP? And there's a lot of literature coming out on the sort of the analytics of IP ownership in terms of patents and inventors and patents and the sort of the gendered racialized implication of that, given the number of patents that are disproportionately held and owned by men, the sort of team patents, who's included on patents in terms of joint inventors and so forth. Again, also, so it's a pipeline, of course, of discrimination from STEMs into faculty recruitment, knowledge production, CRC, citation practices, and so forth. And you see it on the other end too, in terms of IP innovations, and then C-suite. So who is in the top managerial position in these companies that are generating IP and so forth, and how is that reflected? The other aspect of this is we really need clear exceptions. And I mean, I'm a part of a group of IP scholars who recently made submissions on the copyright consultation, which is available online. regarding the need for clear and express exceptions to copyright for text and data mining. Now, we think that such allowance can be established on the law as it is, but I think it would be really important to have clear exceptions to allow for text and data mining, so that you can have more broader and inclusive data sets, so that the training is not limited by the data set. So, for example, in natural language processing, you can imagine this relates to quality data issues. You can imagine if you can't access broader literature, like in terms of data sets that are currently behind paywalls, and you're limited to things that are out of copyright, then those things out of copyright may reflect more gendered and discriminatory language of prior years and prior cultures. Times have changed, right? We have in our literature now gender, neutral pronouns and so forth, and so the capacity to be able to deal with that as part of the natural language processing, but also in translation and so forth, that is deployed. So there's lots of areas of interest, and thank you for asking that. So it will be part of the next project to sort of deal with those as impediments or supports for EBD.
Yeah, that you raise really good points, that it's not just one area of intellectual property law. In fact, it's sort of a holistic approach that's needed, and that it also touches on things like copyright. And I've seen that report, or sorry, the submission that you've drafted, and I'd like to read it in depth so I can glean even more from that. I want to turn to an audience question here. Keith Douglas, who has said that they work as an application security specialist who advocates for value-centric design all the time. But one problem this person encounters is difficulty in software developers turning values into code, even with a well-established detailed description, in their case of a security control type or even token. So their question is, what would you propose would change in a well-known specific algorithm rather than the data fed into it? And then that means taking the talk at the face value. And how would this change and promote equality by design?
Okay, so thank you for that. A really thoughtful question and a challenging one. I think one of the key problems is commensurability, right? So there is a language difficulty between social scientists and computer scientists, and the language that they speak suffers from a commensurability issue, I think. So even if we look at the concept of gender binaries, for example, and language and the challenges there. So I do think that the challenges are not only in terms of the data set, but also the design aspects. But how to address those in a meaningful way, I think, really requires collaborations. And with social scientists and data scientists and computer scientists in addressing those issues. With the EBD proposal, like privacy by design, you can establish the requirement and the requirement, you can even go further and say it needs to meet the substantive equality criteria, not formal equality, because law may be formally neutral on the face of the text, code may be formally neutral on the face of the text, and yet substantive equality is really important. So what would you propose with respect to change in well-known specific algorithm? I'm not really sure what to propose because I don't have the expertise with respect to the computing aspects, but I think it requires minds within computing and within social scientists to get together and try to have a form of translation of values into design approaches that would be enabling of the implementation of EBD. One of the benefits, as I was mentioning, is that once you articulate the standard, that means the hard work of infusing that has yet to be done, but can actually be in part left to the innovations of industry as well as others to help generate the content of that. And a lot of growth in industry and development tools has occurred, for example, in privacy, for ensuring privacy and compliance and privacy assessments and so forth. I had the pleasure of speaking to a Cantech conference presenting this talk as well with the CEO, one of the CEOs and founders of Fairly, and they've developed a whole sets of assessment tools for identifying risk and bias and so forth. And so I think a lot of development we can expect will be coming out from industry, but I don't think we can leave it entirely to industry and trust this will be achieved through industry standards and so forth, because the broader public interest is cannot be abdicated to industry, nor can the legal compliance measures be entirely left there. There are some requirements for sort of entrenching these as legal defaults, which the paper talks about, but I haven't talked about in this context of the talks.
Yeah, thank you for that. And I think it is, difficult to answer what would change in a specific algorithm, because it really depends. It really depends on the purpose of the algorithm, as you said, because if it has, if the algorithm has the outcome of what seems like formal equality, so treat white and black people the same, when in fact substantive equality is needed, which doesn't mean treating everyone the same, then you can't, advise on what the algorithm should look like, because it really is context specific, is what I hear.
And moreover, if we take the obligation for special programs seriously, then in fact we can expect that there should be development of some algorithms that will not treat people the same, because they're structured to alleviate historical inequalities, discrimination, and structural harms. So this is a really tricky thing, and I have I don't have the answers, but I'm here to pose the questions and outsource the creative thinking to all of you folks to help generate some of the answers.
Yeah, I love that, and I love that the work of your work is very optimistic and wants to set the tone and says, "Here, let's work together to solve some of these problems." But I'm not going to have all the answers either. Thank you for that question, Keith, and please keep them coming, because I think we all have so much to learn from you, Professor Amani. And I just want to acknowledge as well that Marcella Day has said that folks here might be interested in the 2021 final report of the Australia Human Rights Commission following their recent research and discussion papers cited by Bita, which I'll be curious to check out myself. In the meantime, while folks are thinking of questions and comments, I will ask a few thoughts that I had in regards to your talk. So to bring your talk into something that has been on my mind lately, we know that Canada has been praised by some for taking the lead globally with its risk-based approach to AI in the public sector. You touch on in your paper as well the Directive on Automated Decision Making, which is managed by the Treasury Board Secretariat and requires federal government agencies to engage in risk assessment and mitigation when they use AI systems in external administrative decisions. In late October, though, reporters at the news outlet Delogic got their hands on an internal report which indicated that these rules are too narrow and that they only apply to a very limited set of cases when a decision making is involved. So it isn't just recommendations, it's when the system makes a decision, and when the tool is used for administrative decisions, such as, for example, immigration, and only for external services, so not for internal things like hiring. And more than this, the reporting showed that algorithms that are used need not be tested for bias. What do you make of those findings, and what would you say to the Treasury Board Secretariat about the development of the directive in the future?
Well, I mean, first off, it needs to be compliant with international law. So CETA, again, requires, for example, the elimination of all forms of discrimination against women, and the other instruments I've referenced have similar provisions for racial inequalities and disability. And so those generate positive obligations. So, for example, under CETA, the gender-based analyses, gender-based impact assessments are required by law. And so implementation of those obligations is really key and critical. Secondly, this is the problem with data. Metrics are malleable and need to be situated in the society again. So Sam Gabru in that recent gender chapter I mentioned talks about standardized tests, for example, and IQ tests and so forth, and then studies that look at sort of differential intelligence by gender, using the tests as the proxy or metrics for intelligence without actually questioning who made the tests, what are the tests actually testing, and so this is a critique of standardized tests more generally and so forth. So data and the assessment of data is directed by these broader questions. So we have a great directive that addresses procurement and AI development by government, but it talks about impact assessments, but in terms of economic impact, but it doesn't really talk about impact assessments requiring safeguards with respect to equality, for example. So I would suggest that the directive, and this goes back to the sort of AI strategy more broadly speaking in Canada, you need to have funding that is tied to ameliorating these systems themselves. So their parameters, the metrics, the designs of the actual systems that are then used to advance the criteria of other systems, right, that are going to be used. And that becomes really, really important in particular given automation bias, so the preference to prioritize a decision that's made by AI over a decision that's made by humans. If there may be a false consciousness or a false sense of security that comes through that process that will further allow and entrench automation bias, which, if not held to check by sort of a broader lens or a broader intersectional gaze of how it actually operates, may actually really be undermining. It may be part of sort of what we see in terms of trends of virtue signaling or ethics washing or greenwashing or whatever else that may occur. The other thing I really want to encourage is sort of the infrastructural commitment. So EBD is not just sort of internal in terms of the algorithms and their impacts, and so, but it's also sort of a broader. If we look about this talk is based on AI and society initiatives. If we look at the broader society initiatives, we need to focus on infrastructure. We need to focus on accessibility, so the use of CAPTCHAs and the implication for exclusion of the visually impaired and so forth. So the lens really needs to be cast wide, and there's a lot of work for a lot of great minds to do together because really I think the problem is the siloed effect is not going to get us there in terms of transcending the complications of administering and regulating and implementing equality.
Yeah, those are really great points. And you talked just in the beginning of what you just said about Tim Nguyen-Bu's criticism of IQ tests and how they work and who's created those. And it seems to me that your work and your chapter is really, takes a look at the bigger picture. And I know in one part of your chapter you talk about how CFAR and there's this pan-Canadian or artificial intelligence strategy for Canada, and they fund things, but part of that funding you say should actually be used to help predict whether a project that is funded will have disparate impacts on marginalized communities, and you think that there should even be separate funding for projects that analyze the quality impacts of AI using computational methods. And that to me seems parallel, because you're saying you need to address this at the very root of this, and it's not just about the impact, but it's actually about the data, to hearken to what Keith has mentioned, it's about the sort of pipeline and the origins of the tools and the sort of construction of them from the very beginning.
Yeah, absolutely, and thanks for actually referencing that. It really is the construction of the tools, sort of a priori, that needs to be examined. And I mean, we see the funding bodies have made efforts, right? So the Social Science Humanities Research Council sort of has adopted policies regarding inclusion, the sort of equality, diversity, and inclusion, and so forth. And so you see that on their website that's being reflected. And so again, you see this adopted, and even in other areas, we have good precedents in terms of Genome Canada's inclusion of a person that can address sort of ethical, environmental, social, legal considerations, but it's one person usually on a team, a multidisciplinary team. In that context, that usually has occurred. So funding bodies do provide some increasing recognition for sort of collaborations or even demand for such collaborations, and also for recognition and signaling of equality, diversity, and inclusiveness in projects and teams and applicants. But the problem is there is so much pervasive inequality that that algorithms reproducing such inequality will exist is almost to be expected. But the greater problem or concern is that it's on scale, right? So it's the scaling up of that, and the implications in terms of burdens, costs, and for the everyday individual who's entangled, sometimes unwittingly, in these systems of government.
Yeah, definitely. Yeah, it's not easy, and it requires looking at things from the very source, which I think and that's why what's like a major sort of accomplishment of your piece is that you've really identified the need to peel back those layers. I want to.
But just on a positive note, I really do think, I've had some conversations since presenting this work with some computer scientists regarding, coding for equality and so forth, and equality as code, and so the subtitle being a code for all codes, right, and so forth. So I'm quite optimistic, but I think it requires mindful dedication and commitment and political will.
For sure. And actually, yeah, I also think I've seen some shift in funding requirements too, where, yeah, when you apply to funding for the federal government, they do require you to engage in gender-based analysis, for example, in the course of their application. So yeah, there's definitely hope. I hadn't actually thought of this question. I'd be curious to hear your thoughts. I know that there's a movement within the computer coding community, or a subset of the computer coding community, to remove language that is reminiscent of slavery. Or can perpetuate racial bias or racial discrimination, such as slave and master. I don't know if you're aware of that. To me, it seems like it's a part of the conversation, but it's adjacent and slightly unrelated, but related. Do you have any thoughts on the need for changed language in the coding community? Does that seem like it relates to your work at all, or am I sort of taking it too far afield?
I'm not sure I'm fully maybe appreciating the context of that discussion, so I would love to see, or maybe you could throw me some things to look at and read. But I know that I was really interested in the work of Biasly through Mila that looks at effectively allowing sort of a plugin for users to sort of catch biased language. And that's a really useful tool, for example. And initially it was, I think, based on gendered language, but now I think is also inclusive of racialized language. And that's a really useful tool. It's a public interest value there and it's great in terms of running your, ads, recruitment ads through that, or other things that, that are forward facing through such a tool, I think. So again, really great developments and innovations that are coming out, and some of them are open source and accessible and available for free, and whereas others are proprietary, of course. But so there's that. Now, if your question talks about the capacity, sort of the revisionist capacity to edit the record, the historical record, in some way, that I because I sort of believe in the significance of the archive and sort of maintaining the truth of that record. I think that I wouldn't support that at all, and we see some of the movements in the U.S. with respect to critical race theory and the ban, or to remove works from educational context and stuff. In fact, disenfranchising people from marginalized communities that have drawn attention to these areas. And to me, that's sort of a wrongful taking of, again, intellectual property rights in some ways, because if you think about it, and this is yet another thing I'm working on, but if you think about it, like we've seen this in other areas. Not only are there differential treatments in the subsistence of rights and who can acquire them in intellectual property. So, for example, women's gendered labor and craft work or cooking was not recognized, but once that labor became profitable, so for example, chefs took over and extracted value. All of a sudden now there's discussions regarding, artistic works in terms of copyright or cake designs or whatever else and stuff like that. And so we see that in various areas, and there's great sort of historical, there's a book I can't remember the name of right off the top of my head, but that talks about how computer science was originally a very female-dominated, computing was a very female-dominated practice in prior to the 1970s and so forth. But once it became lucrative as an enterprise, and it sort of became more male dominated, and then so women then were sort of cast out of that enterprise. So this is a way of really basically confiscating value. So not only, so it's like, for example, where obscenity trials may ensue with respect to intellectual property rights on rap music, right? Or so obscenity allegations may be raised as a way of curtailing the exploitation of intellectual property rights, even where they exist. Same thing with the ban on books, right? On various books, on various records, has the same kind of implication. So even where intellectual property rights exist and have been found to exist, the movement in the states that we see occurring with respect to the restriction on what books can be read or can't be read, and the curriculum and blah, 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 which has a disenfranchising effect, is really just another way of dispossessing effectively various communities of distributional property rights that have real economic consequences.
Yeah, absolutely. And I feel like I just sort of threw you a curveball there, and I think your response, there's so much to this, and just for the context, I shared a New York Times piece on the movement. It's actually really been since the wake of the murder of George Floyd. It's like every community, or these various communities, are sort of reckoning with racial justice and what it means in their community. So I feel like it's just sort of an outpouring of that, and it's contentious, and it's a bit convoluted as well. So it's not simple.
Thanks. I haven't read it. To take a look.
Yeah. It's interesting because it makes me think of the sort of root issues at heart here. Now, in terms of remaining questions, I do have a few, and I see that there's none in the chat. And I want to talk about any limits that you've ever encountered to the human rights approach, or any sort of perceived sort of challenges or things that people, critiques that you've faced, or barriers. I'd be curious to hear about how people push back on what you're advocating for and what that's like.
Well, I don't even think the pushback is necessary, because I readily observe the critique as internal. There is an internal critique. I think it was Alan Sykes who had mentioned in general, with respect to human rights are income elastic, right? So the ability to promote, uphold, claim human rights depends on infrastructure, judiciary, public institutions, personal economic capacity to, again, this is the access to justice issue. So the human rights approach has those types of limits, which is why, again, the EBD approach is a really good one, because I think it takes that burden off the individual and places it where it should be in terms of the perpetrator of the harm, or the developer of the tools that advance the perpetration of the harm. The other thing that I think a human rights approach shows in terms of its potential limits is, again, the concept, the critique of the sort of individualized atomistic conception of rights themselves, right? So, even the human rights instruments have sort of had some critique of sort of the mechanism by which they were implemented in international fora, in sort of twin institutions and instruments for greater economic integration and codependence through human rights recognitions and trade, in post-war times. But really being sort of an agenda that may have had their origin sort of in a sort of more westernized conceptions of rights to begin with. And so one of the limits of the human rights approach may be, again, that if it is really limited to this concept of individualized rights, then that individualized rights may sometimes be advocated by way of the individualized capacity to consent to things and so forth. And again, so this really generates some of the critiques that we see in the privacy context with respect to consents, and whether individual consents can be considered to be enough. Do people really understand what they're consenting to? Can they consent to it when the harm is we might ask, can the person consent to something when the harm is not just individualized, but it actually is aggregated, it's systematic, it actually the totality of the harms the sum is greater than the individual parts, right? That is when identity construction is generated across the board. So Sophia Noble's work, for example, in terms of the search of Black women generating top hits with porn sites ranking, even if the word is not used, is sort of a systemic harm for the politics of identity construction. You know, Tim Gibber's work that references when the voice of our assistants, personal assistants like Siri and Alexa, are all female, the sort of the encoding, the socialization of people in households that females are in service, are assistants, are, you know, and so forth. The implication of that in transforming identities and socializing certain normative values regarding identities, and that, you know, when we get mad at our navigation devices and you're yelling at the device, or, you know, with words that may not be, you know, sometimes that's, you're yelling by anthropomorphizing the machine, right? Like you're saying, oh, you dumb whatever, or oh, I can't believe she doesn't understand, or whatever, because the voice is feminized. So it's the feminization of certain values and qualities that are reflected in that, and the implication of that for the socialization of people within a particular environment, within a society, and within a particular context. So
yeah, it's I think it's true that you know, Jane Bailey has work on the community-based approach to equality and equity, and I think that's what your work reminds me of, and what you're saying now, you know. So Florian has appeared on the screen, which means we should be ending. I did want to ask if you had any final words, but I would happy to let Florian take the lead on ending it if that makes more sense. But Bita, if you wanted to sort of end with any final messages or any sort of summary of what you'd like us to walk away with, happy to invite you to just share that.
Yeah, thanks. Actually, first of all, it's been an absolute joy. Thank you for the questions and the discussion points, and thank you as well for having me. Really, I just think that, you know, there's a lot of hard work ahead of us, but overcoming systemic inequality is not new to this domain. And if we want to have better, fairer, ethical, trustworthy AI, we will need to have better, fairer, trustworthy society and social institutions in which AI is embedded. And I think that's pretty well where I will leave that. I invite any and all of you to participate in our annual International Women's Day Conference that I co-organize with my colleague, Professor Kathleen Leahy from Feminist Legal Studies Queens, to engage in some of those bigger challenges. And the other thing I really want to say is the 2030 pledge for leaving no one behind is something that really needs to be considered as a key commitment in the areas of development here. And it was in the trustworthy guidelines that was put out by the EU. And it really needs to operate, I think, in all jurisdictions as part of the commitments in the strategies and initiatives undertaken here. Leave no one behind.
Yeah, thank you so much for that. Thank you for that message.
Yes, perfect. On those amazing words. Sadly, I think we need to stop the conversation here because it's close to 1 p.m. and people have classes, meetings, or lunch break. But thank you so much, Bita, for coming present your work to our community, and thank you so much, Yuan, for facilitating the conversation. I think it went super well. I was super interested. I have so many questions, and I will follow up, Bita, by email about this. But yeah, so thank you for everybody in attendance, and I hope to see you soon. And I will just flag our next event on December the 7th. We will have the pleasure to host Frank Pasquale to discuss his latest research on algorithmic accountability for mental health apps and other field where there's so many issues for the use of AI. So on those words, thank you again for everybody for being in attendance, and see you soon. Bye-bye.